The court issued one of the most important decisions in the case of Ripple v. SEC. The SEC case against Ripple took a new turn after the amicus curiae brawl. The SEC's last step was to file a comprehensive motion to exclude or restrict expert testimony. According to court documents, the Ripple team accepted this petition on condition. Welcome to the Finance Up channel. If you liked this video, don't forget to like it and subscribe to the channel. Do you think the analysts are right about XRP? Write the answers in the comments. Giving away 500 XRP at the end of the week. One random subscriber will receive XRP coins. Take a look at the instructions in the comments section. All you need to do is write the word XRP, watch the video to the end, to like and subscribe. The SEC's regulatory oversight body filed this petition on July 6, as well-known lawyer James K. Phelan reported in a thread. The SEC intends to file petitions to exclude or limit the testimony of 10 experts hired by Ripple Labs. This may also include independent experts such as Christian A. Larson and Bradley Garlinghouse. The Securities and Exchange Commission has requested permission to file one comprehensive, large motion to exclude or limit expert testimony to 120 pages. Ripple's defendants do not object, provided they are allowed the same page limit for their objections. Called an attempt to preserve judicial and SEC resources, Ripple accepted the motion on condition. The condition allows them to have a similar page limit in their response to traffic. It has since been accepted by the SEC and is now approved by Judge Torres. The proposed limit of 120 pages is less than the proposed limit of 15 pages per expert. The Securities and Exchange Commission believes that this limit will be sufficient for the Securities and Exchange Commission to present its facts and support its position on the case. With this move, the drama of the court battle between the SEC and Ripple is taking it to a new level. Let's see what the consequences were for the XRP token. The court granted Ripple's petition and allowed her to add 2 new lawyers to her legal team. Earlier, the petition was rejected because it did not comply with the rules, after which an amended petition was filed. Both motions to appear pro hac vice have been granted. The court granted the SEC's request to file a 120-page consolidated petition. District Judge Annalisa Torres granted the SEC's request to file a 120-page consolidated motion to limit or exclude the testimony of 10 Ripple experts. District Judge Torres has granted the SEC's motion for permission to file a 120-page omnibus, big, motion to exclude or limit the expert testimony of 10 Ripple, Garlinghouse or Larson experts. The defendants did not object to this request, but demanded that they also be allowed the same page limit when filing an objection to the SEC proposal. A legal expert warns that an unfavorable decision on the U.S. Securities and Exchange Commission (SEC) lawsuit against Ripple will be bad for the cryptocurrency. John E. Deaton, managing partner at Deaton Law Firm, says the outcome of the SEC lawsuit alleging that XRP is a security will determine whether almost all other existing altcoins are securities. Given that the U.S. Congress is not going to clarify regulation, especially in an election year after the Supreme Court overturned Roe v. Wade, the decision of Judge Annalisa Torres in the Southern District of New York will decide whether the SEC has jurisdiction over existing altcoins that have been traded for years. The SEC not only claims that the way Ripple offers and sells XRP is illegal, but also that all XRP are unregistered securities. This is the functional equivalent of the statement that oranges are groves in the SEC v. W.J. Howie Co. case were securities. If successful, almost every second altcoin is a security. Quote, the case as SEC v. W.J. Howie Co. related to the Howie test, which is the standard used to determine what is or is not a security under U.S. law. Consequently, and in response to the lawsuit filed this week against the developer Solana Labs, which claims that the 9th largest crypto asset is a security, Deaton says that there will be more such lawsuits against crypto organizations if XRP is recognized as a security. Safety. Only the beginning if XRP is considered a security. Most likely, dozens, if not hundreds of class actions will be filed, but not only against exchanges. Coinbase has already been sued, but also against the alleged promoter of altcoin. Ripple has already been sued over XRP. Quote, experts claim that the plaintiff intends to file this petition in order to put pressure on the company's defense team and exclude initial and/or counter reports on various topics with the participation of experts. Several requests are contained in the consolidated petition. Court petitions allow the parties to systematically present or raise additional issues related to the case. According to the Securities and Exchange Commission, the defendants agreed to a summary that would not exceed 120 pages, provided that the same length limit would apply to their opposition response. The SEC also had no objections. Lawyer Fred Rispoli discusses the significance of this, saying, "Ripple will also oppose the SEC experts. Now you understand why Ripple recently hired 2 more lawyers." Quote, "The case represents an escalation of an already fierce judicial conflict that has repeatedly made headlines." The deadline for making a decision on the petition is set for July 12. The future of cryptocurrencies depends on a specific case brought by the SEC against the fintech company Ripple, whose $15 billion XRP currency ranks 7th in market value. The lawsuit, which was filed on December 22, 2020, claims that Ripple illegally received more than $1.3 billion. The Securities and Exchange Commission claims that Larson and Garlinghouse neglected the legal indication of their offer and sale of XRP to investors, depriving potential buyers of sufficient information about the cryptocurrency and the nature of Ripple's operations. If the SEC wins its legal standoff with Ripple, XRP will be classified as a security and not as a digital currency in the United States. This may create a legal precedent that will lead to the classification of other cryptocurrencies as securities. Now we can only guess when this eternal judicial fight will end. Meanwhile, the price of XRP has increased by 8% compared to the previous week, and analysts expect the altcoin's uptrend to continue. Lawyer James Phelan said on Twitter that the application for admission was rejected due to non-compliance with local regulations. He noted that the testimony was not notarized. Meanwhile, Phelan later stressed that the amended applications for admission to Pro Hack Vice have now been filed with notarized affidavits. The new supporters who have joined the Ripple team belong to Kellogg Hansen. The defendants call this a huge step, as the long-standing trial is now moving towards a simplified trial process. Attorney Jeremy Hogan stressed that the new addition will allow the team to conduct additional research before proceeding to decisive proceedings. However, he also mentioned that an important decision will be made this week on Hinman's emails. In the meantime, the Commission has filed a letter requesting permission to file one comprehensive motion to exclude or restrict expert testimony. He added that the defendants do not object to this petition. Ripple will also be able to file an objection within the same number of pages. The SEC also agreed to this request. The current price of XRP for today you can see yourself on the screens, and the trading volume for 24 hours is $1,294,436,065 US. We are updating our XRP price in US dollars in real time. XRP has dropped 4.08% in the last 24 hours. Do you think XRP will be able to win the court and restore its former price? Write the answers in the comments. That's it for today. Thank you for watching this video to the end. If you liked it, then don't forget to like it and subscribe to the channel.